Heidi, do you want to take us off?
Oh, I thought Liz was just going to even do like a little brief intro. Hello, all. Welcome to today's webinar for the Home Care Association of Louisiana. My name is Heidi Kocher. I am a partner at Lyles Parker, and joining me today is going to be Matt Cato, one of our other attorneys in the firm. A couple of housekeeping items. Everybody is on mute at this point. And yes, you will receive a copy of the slides. They will go out either this afternoon or tomorrow morning. I'm not familiar with the particulars of this particular webcasting system. But in any case, so today's webinar is responding to a potential privacy or security breach. And we're going to discuss some internal and external strategies to help you do that. As said, my name is Heidi Kocher. I am a partner at Lyles Parker. I've been doing healthcare law for over 25 and almost 30 years at this point. I represent providers of all kinds, physicians' offices, clinics, medical device, and quite a few hospice and home health care agencies. My practice ranges all the way from transaction matters through regulatory, and I also do a lot of work in the HIPAA space. As a matter of fact, I am waiting for the closure letter from OCR on a breach that one of my clients has had. So I'm very happy to be doing this webinar for you today because I think education is such an important part, and knowledge is the most important thing that you all can have in relation to HIPAA. Matt, do you want to introduce yourself, please?
Sure, absolutely. Hello, everybody. My name is Matthew Cato. I am also an attorney at Lyles Parker. I can't claim Heidi's nearly 30 years of experience, but I did work with the Department of Health and Human Services, both their investigation and legal team, before I saw the light and came back from the dark side and started representing providers on the side of good again, as opposed to being the government enforcement agencies. I have experience not only in HIPAA breaches, as Heidi does, but also their cyber counterparts, and most fun for everybody, dealing with the insurance companies and how that process generally resolves, what it looks like, some general pointers, and what have you. I would like to go on just to clarify, as Heidi and I are both attorneys, we do have a disclaimer that we do have to read out before we get started. We are attorneys. We are not your attorneys unless you choose to, for whatever reason, engage us specifically through the firm Lyles Parker. Any and all information given during this presentation is strictly informational and targets general trends or tendencies that we've seen in the field that we want to make you aware of. It should not be used in place of legal advice or duly retained counsel, and every case is different and unique, and one fact can change the whole paradigm. And with that out of the way, I think we're ready to get started. Heidi, do you want to take
Thank you, Matt. Yeah, also, I just need to let everybody know I am on the tail end of some upper respiratory thing, so I apologize if I need to cough still in the middle of it. Whatever's been going around this summer has gotten me as well. All right, so what we are going to do again is talk about breaches, and one of the things that I want to do is set the stage. Remember that HIPAA is a federal statute, and what it does is it sets a floor, not a ceiling, and many states actually have their own medical privacy or laws or reporting regulations that are more stringent than HIPAA. And so if that is the case, they will preempt HIPAA, and a patient or a provider, a patient in those states or a provider in those states is either entitled to or must comply with those more stringent regulations. Remember that state regulators can also get into the mix when you have a breach. And in some cases, the penalties for state privacy breaches can actually exceed those under HIPAA. So you need to double check your state. Again, some states, such as Louisiana, do have some interesting language and different language, and so you want to be aware of that. But in the interest of today, we're going to focus on HIPAA federally rather than the state statutes. Next slide, please. I'm not going to go into all of this. This is a little bit of the history of HIPAA, but you do need to understand that the security standards were issued in 2003, and the enforcement, the breach standards, were issued in 2006. Some of you on the call may have kids in college who were born after these rules were published. And I mention this because the regulators have taken the position that these standards are around so long that everybody really needs to understand what they are and know what the requirements are and really should be meeting them. There's really not going to be much more of an excuse anymore for entities to say, well, I didn't know I had to do this, or I didn't know I had to do that. That is not a winning argument when you are faced with a HIPAA breach. Next slide, please. One thing I do want to point out is that in January, there was a proposed rule published on enhanced HIPAA security measures. And that it's not exactly a breach, but it touches on it a little bit. Those comments closed on March 7th, and now we are waiting to see what happens with that proposed rule. Let me just say that if the proposed rule becomes final in the language that was in the proposed rule, there are going to be significant additional things you as providers will have to do. And so I think one of the things that you should be doing now, if you haven't done them yet, is get your houses in order and at least meet the old rules, because the proposed new rules will have even more requirements on them. All right, next slide, please. So basics, who and what does HIPAA cover? There are covered entities, as you all know, which is a health plan, a clearinghouse, or a healthcare provider who transmits health information in electronic form in connection with a standard transaction. That's basically things like submitting a claim for payment, receiving payment, doing insurance verification, and so on. Technically, under the federal HIPAA laws, if you have a completely paper-based system, you don't have to comply with HIPAA, but I don't know but of one or two providers anymore that is completely paper-based. If you take Medicare or Medicaid, you are engaged in standard transactions and you are required to have a certified EHR that is going to comply with the security requirements, and of course, therefore, you're doing standard transactions and you're covered by HIPAA. Business associates is pretty clear. They're people who do things for or on behalf of a healthcare provider. And then if you have a hybrid entity where you have some business activities that cover both covered functions, include both covered or non-covered functions, then the HIPAA rules only apply to those healthcare components of the facility. I will say that one of the trends that we've seen is that people who technically aren't covered under HIPAA are actually stepping up and agreeing to comply with the HIPAA rules because they have PHI in their possession. Next slide, please. So one of the things that we did want to talk about is that under HIPAA, the law allows for what is called scalability. And the scalability is a recognition that smaller providers may not have the resources to do some of the things that larger providers do. You may have the space, you may not have all of the resources, etc. One of the things that I do want to emphasize is that scalability does not mean compliance with the particular standard or reg is optional. Even though it's scalable, you still have to comply. You just have some flexibility in how you comply. And in looking at the security measures, they're going to look at four things. They're going to look at the size and complexity of the organization, what the technical infrastructure is of the organization, the cost of measures, and the probability of risk. And that's pretty important. If you choose to not go whole hog on something, you'll want to be documenting these factors as to why you have not taken a particular route and are choosing a perhaps less robust route. Next slide, please. And the reason that, by the way, that we're talking about this up front is because when you have a breach, it is too late. Addressing a breach really starts with laying the foundation for compliance in advance before you have any issues. So you need to be understanding what your obligations are, because if and when you have a breach, OCR is going to come and ask you about these things. So you need to know what is out there. So again, remember that patients have rights under HIPAA as well. Essentially that you keep their information secure and private. And here the minimum necessary standard applies. So the key question is, does an individual need the information? So for example, the front desk people may not need the entire history of the client. They may not need access to the billing portion. They may not need access to lab results. So you really need to think about what is the minimum necessary for that individual to do their job, and then make sure that your EHR can grant roles-based access so that not everybody has access to everything in the patient's medical record. Next slide, please. So again, patients are required to have privacy rights, and so this is what you're going to put in your notice of privacy practices, that they can receive an NPP, notice of privacy practices. They get to know when and to whom there has been a disclosure. This is very important because when you have a breach, you have to notify patients, right? The patient also has the right to request restrictions in how the provider communicates information. So for example, the patient may say, don't leave any messages on my cell phone. You have to comply with that then. The patient has the right to access records, inspect and copy their records, and patients can access this information for 6 years. Now, many states actually allow for fees in copying, but HIPAA has had some cases, and OCR has come out and said that the limit on copying fees and fees to produce records is much lower than the state limits. So you also have to be aware of this because, again, this may come up in a breach where patients want to say, I want to see what my records were. And of course, patients have the right to make amendments or the corrections to their records. That doesn't mean they can take records out of the file. They can just add something that adds context to the records in the file. As we have here on the slide, they can put in their 2 cents. And then finally, a patient has the right to complain of violations. And this comes out because often one of the ways that a healthcare provider is aware of a breach is they get a patient complaint that perhaps their credit card has been utilized or something like that. So you need to be aware of what the patient rights are as well. Next slide, please. All right, penalties. This is very important because, again, a breach is going to lead to penalties. So under the High Tech Act, which was passed in 2010, there are now tiered penalties. And the range of penalties sort of depend on whether it's a first-time offense or all the way up to whether or not you did something deliberately. Under High Tech, business associates are independently liable for HIPAA compliance. And again, if you have something going on with a business associate, the business associate cannot threaten or retaliate somebody who files a complaint against them. So if you're using a billing service and your patient files a complaint about the billing service, there can be no retaliation against the patient. Next slide, please. So these are the tiers of penalties. The lowest tier is if the offender did not know and by exercising reasonable diligence would not have known that the law was violated. This is pretty much, we did everything we could and knew that we should do, and something still happened. Second tier is if the violation was due to reasonable cause and not willful neglect. The third applies if the violation was due to willful neglect but was corrected. So this is an instance where people say, you know, HIPAA just sounds like so hard to comply with. We're just gonna skip on some measure, and then a breach happens, and then you correct it. That's what category C is. And then the final tier is if the violation is due to willful neglect and was not corrected. We have stories of entities that have had breaches. OCR found out about them. OCR went to them and said, you had a breach, you have to report this. The entity failed to report it. OCR months later and said, we told you you had to report this breach. Please make sure you file a report. And the entity still failed to file a report. And then, of course, they got popped for a substantial fine. Well, that's the category D there, or the fourth tier. It was willful neglect and it was not corrected. Next slide, please. So these are the dollar tiers. As you can see, the lowest tier, tier 1, has a minimum penalty of $141,000, and it goes up to $71,162. If you have lack of knowledge and you didn't know what was happening and you did everything else you could do, OCR tends to tilt to the lower end of this range. Second tier, tier B, reasonable cause, lack of oversight, the penalty jumps by a factor of 10. So now you've got your $101,424 is your minimum. And then for willful neglect but fixed promptly, that jumps to $14,000, again, a factor of 10. And then finally, willful neglect not corrected. The minimum penalty here is $71,162. Note that the annual penalty cap is $2 million just for the civil monetary penalties. We're not talking about other kinds of penalties. We're not talking about states. We're not talking about class action suits and so on. Next slide, please. Here are some recent case examples where you can see how the penalties can add up. So Hospice of Northern Idaho, the last two on the bottom, are actually very specific home health and hospice cases. You can see there that Hospice of Northern Idaho actually had only 441 patients and got a penalty of $50,000. That's over $113 per patient. Again, I think that money can be better spent up front as opposed to having to pay it in penalties. Centara Healthcare had a home health agency, and essentially what happened here was results of patients got sent, lab results got mixed in with the wrong patients and mailed out to the wrong patients. 577 patients affected. They paid a $2 million fine. Now, there were some other things at issue in Centara as well that we'll talk about, like failure to do a risk analysis. But again, you can see how the penalties can quickly ramp up when you have a breach that is reported and investigated by OCR. Next slide, please. So when they look at this, they're going to consider a number of factors. And this is, again, for civil monetary penalties. We're not talking criminal. There are criminal penalties for HIPAA violations. This is just civil here on this. They're going to, again, look at the nature and extent of the violation, which includes how many individuals there were and the time period that the violation occurred. They're going to look at the nature and extent of the harm. Was it physical harm? Was it financial harm? Does it hinder the ability to get health care of a patient? They're going to look at the history of prior compliance with the regulations, including whether or not there were prior violations. So one of the things that's going to happen when OCR comes in an investigation is they're going to ask for four things. They're going to ask for your security risk analyses. They're going to ask for your risk management plan. They're going to ask for your policies and procedures. And then they're going to ask for evidence of the training of your staff. That's out of the gate. They will always ask for that. So one of the things this is getting at, this here is, do you have those four things? Again, SRA, risk management plan, training, and a policies and procedures manual. They're also going to look at the financial condition of the covered entity or the business associate that was breached. If it causes you to shut down, they might roll back on a penalty, but they will not eliminate it completely. And we have, again, stories of clinics and providers that were, in fact, forced to close their doors because the HIPAA penalty was so severe. I read one just last week about that. And then the kitchen sink provision, is there any other matter that they should consider? Next slide, please. So again, a couple of the primary risk areas that are going to lead to a breach, which leads to an investigation and fines and penalties. Impermissible uses of disclosures of PHI. We are seeing the signs that this is no longer somebody inappropriately accessed the record, but this is hacking and IT issues. And we are seeing criminal prosecutions in this space. Lack of safeguards. The big question here is, have you conducted your annual security risk analysis? If not, that will right away, ding, 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 get you major penalties. And as I said, this is one of the four things that OCR will ask for. Another thing that they're going to look at is, do the patients still have access to their PHI? So far, OCR has actually resolved 25 right of access cases, and they have a special enforcement initiative on that. This typically is a situation where the healthcare provider fails to turn over records to a patient requesting it. But remember that a HIPAA covered entity has 30 days or 60 days if you get an extension to provide the records. But here's the situation. If you have some kind of a breach and your backup, you don't have a backup, or your backups are locked, or you have ransomware or something like that, and you cannot give a patient access to their records, that could very well involve a right of access and can get you in the crosshairs for that. And then finally, use or disclosure of more than the minimum necessary PHI. Almost by definition, a breach is going to involve the use or disclosure of more than the minimum necessary because, I mean, that's almost in the definition of a breach, right? Somebody shouldn't have had access to this and they did. So these are the risk areas you want to think about and the background to all of this. Matt, you want to take it over with enforcement initiatives?
Sure. So I get to start with the part that is a little bit less fun and start talking about our friends at the Office of Civil Rights, the old OCR. On your screen are a series of enforcement initiatives that we've noticed that they're paying particular interest to going into the year 2025 and under the current administration. Our first question for this is, have you as an agency conducted your annual HIPAA high-tech security risk analysis assessment, which is a whole bunch of fancy words of, have you checked that you're still in compliance with HIPAA? If not, we strongly encourage, read as, you really, really should do it right now, immediately. In the event of a breach, this is one of the first questions that OCR asks and looks for. They use it as a mitigating factor towards some of the penalty tiers that Heidi was referring to earlier. If everyone took all reasonable steps, this is the first step they look to. Did you analyze your HIPAA environment? Did you address breaches where they were apparently relevant? And did you take steps to minimize exposure where you could? As of June 10th, 2025, there were 9 settlements that we are aware of specifically for the failure to conduct these security risk assessments. And each penalty can get up to over $250,000. The second enforcement initiative we've seen is a lack of access to patient PHI. This is a bit of a tricky one insofar as the OCR frames this as a right of access violation under HIPAA. Under HIPAA, individuals who have duly proven either A, I am the patient in question, these are my records and I want them, or B, they are some established guardian, legal representative, next of kin, spouse, someone who is legally in a position that they can be authorized to receive and view these medical records. We've noticed an uptick in OCR enforcement on people not getting those records timely once all the necessary security checks have been undertaken to make sure these people are who they say they are. The short version is, if the patient can either prove it is the patient themselves or someone is requesting on their behalf and is legally authorized to do so, HIPAA generally authorizes a 30-day period or 60 days if an extension is applicable to provide an individual or their representative with their records in a timely fashion. Failure to do so can and has recently led to OCR enforcement initiatives. Ransomware and random audits are the last 2 enforcement initiatives on your screen. Ransomware is exactly what it says on the tin. Your business or your agency was attacked, usually by a third-party threat actor from somewhere overseas, but sometimes right here in the good old United States, someone got into your system who's not supposed to be in there and got access to PHI. There was a 12th settlement announced in April of this year against Comprehensive Neurology. They faced a $25,000 fine and are now under a 2-year monitoring program that they have the outstanding privilege of paying for the costs associated therewith. Random audits are also back on the table. The OCR has restarted all their random audit programs of compliance initiatives and to verify compliance with the HIPAA requirements, OCR can and will just decide it's Tuesday and they want to see proof that you are in compliance. Show us the paper trail. And these are the top 4 enforcement initiatives we've seen so far. Next slide, please. So all of that to say, what is a breach under the privacy rule? Under HIPAA, breach means the acquisition, access, use, or disclosure of PHI in a manner that is not permitted and otherwise compromises the security or privacy. It includes unintentional access or use of PHI by a workforce member or one person acting under the authority of a covered entity or business associate. or excuse me, no, it does not. I misspoke. It does not include unintentional access by a workforce member or person acting under the authority of a covered entity or a business associate if made in good faith and does not result in further use or disclosure in an unauthorized manner. Translated from legalese, this is when a nurse or intern or someone in the office unintentionally accesses a record they have no business being in. There's no medical necessity here. They're not seeing this patient. If they get out, shut it down, don't change anything, don't disclose it to anybody. Most of the time, with some exceptions, that's going to be enough to say, okay, it wasn't a breach and the facility itself is still covered under HIPAA, just don't do it again. There is also an exception for inadvertent disclosures by a person who is authorized to access that PHI at the covered entity or business associate location to another person also authorized to access that PHI in which the covered entity participates and the information received as a result of that disclosure is not further used or disclosed in a manner not permitted under this rule. Next slide, please. Is encryption of PHI required? Contrary to popular belief, no. Covered entities are not mandated by law to encrypt electronic health information. There is no law that says you must do it. However, if you determine of your own volition that it would be reasonable for you to not encrypt a certain set of PHI, then you need to keep in mind that if a breach results from that decision to not encrypt that health information, OCR will take the time to second guess everything that led you to that decision. And there is also proposed new rules that Heidi was discussing earlier that would mandate encryption. It's currently on the table, and as of the time this presentation has not been made into a full part of HIPAA, but they're actively discussing it. There's also loss or theft of unsecured PHI. Section 13402 of the HITECH extends privacy provisions under HIPAA, requiring the covered entities and their business associates notify affected individuals after discovering breaches of unsecured PHI. Usually this can be by an email or a mass email to the affected clients, but you have to be very careful about how you go about this because in turning over this notice, you may unintentionally expose more PHI. This leads me into the breach notification requirements of any unsecured PHI. The breach notification requirements only apply to unsecured private health information. This means that PHI that is not secured through the use of technology or any other methodology identified by the Secretary of State, such as encryption or destruction, excuse me, that renders the paper unusable, unreadable, or otherwise indecipherable. Breach notification requirements of secured PHI are different. If a covered entity encrypts information, whether they made the decision or they just said this is standard business practice, in order to comply with the HIPAA security rule, and they later discover a breach of that information, they are not required to provide notice of breach with an asterisk. We'll likely get into that later, but there is an asterisk. If the breach is too large, you are not required to disclose secured PHI if you took the steps to encrypt it ahead of time. Next slide, please. So the breach risk areas that we've noticed. The first are on the left side of your screen, excuse me, are the four main types of breach that we've noticed. Like I mentioned earlier, your most common one is going to be a hacking attempt. Usually some third party somewhere else in the world has remote access into your systems. They're not supposed to be there. They're not a member of your staff. They have no permission to be there. Or it's some other similar IT incident and they've breached the firewall, or they've gotten in, or they got past the perimeter. The second and third kind of go hand in hand. Improper disposal or otherwise losing protected health information is a inadvertent disclosure insofar as it's your job as a facility staff member to keep that PHI covered under HIPAA. And when OCR comes knocking, at first blush, they're not going to say, was it John, was it Jane, was it Doe, was it whoever? They're going to say your facility had an obligation to keep this PHI protected, and you either didn't dispose of it properly and it got out, or you lost what you were otherwise supposed to maintain, and somebody is paying a bill for it. Depends on how bad the breach is, but ultimately it is the second and third most likely area that a breach will occur. The last is an unauthorized access or disclosure. The most common areas we see of this are people who have no medical necessity for accessing or altering records that are either not their patients, or they're not supporting the primary physician who's seeing that patient, and they really can't justify why they're in this patient's record. It can result in an inadvertent disclosure of PHI and can be considered a breach. Alternatively, if unauthorized access or disclosure is made public to people in the general outside the practice, that's absolutely an unauthorized access or disclosure because they're not supposed to be seeing private health records and information. The location of the breach varies depending on where the PHI is stored. Usually desktop computers and laptops where everybody works and does their 9 to 5 is where your most likely breach areas are going to occur. Electronic medical health records have been known to have been hacked in the past and are susceptible to breach attempts by sophisticated third-party actors, as well as network servers. They can get in remotely through your servers if your practice has a inappropriately defended server is the polite way to phrase it in the cybersphere. Other portable devices, as well as any papers and films on which PHI are recorded and recollected and can be thrown away improperly without being shredded, stuffed in a backpack and pulled out by someone who's not supposed to have it later, or any other number of hypothetical what-if scenarios. As long as that PHI gets into the hands, eyes, and knowledge of someone who's not supposed to have it, that is a breach, and it can occur from any number of the items on the right side of your screen. Next slide, please. So we have noticed on your screen a marked uptick in the number of individuals affected and the unauthorized disclosure and access of exposed, stolen, or otherwise impermissibly disclosed health records. The sharp uptick is reflective of a measured increase in hacking and IT incidents where physician providers, their clinics, their practices, their businesses are under attack by cyber criminals, and they get in there and they take PHI and they disseminate it somewhere where it's not supposed to be, usually some third-party information broker on the dark web, and it gets bad quickly is the whole point of this graph. We put it on the screen just so that you have a numbers reference, and we can move to the next slide, please. So, now that I have properly good and scared everybody, what do you do if you have a suspected breach? The day one incident is stop the bleeding if you can. Now, I've gone over at various points throughout what I've said so far. Most of the time, if they're coming at you in a cyber attack, these are going to be sophisticated third-party threat actors. I will say from personal experience, I have no reason to doubt anybody's personal IT teams, but we recommend that you consult cyber forensic teams to make sure that a full and thorough sweep is done, if you can. If you can remove the unauthorized access, if you can shut them out, if you can kick them out of your server, maybe even go so far as to unplug certain devices. If you can stop it, you absolutely should. The next step is someone's calling the lawyers. I don't care if it's the chief medical officer. I don't care if it's the secretary. Someone needs to get a lawyer on the phone now. While we determine how bad the breach is, we are aware that a breach has, in some form or format, occurred, and you're going to want legal counsel for it. As Heidi was mentioning earlier, we here at Lyles Parker can assist with that, but we are not necessarily the only folks out there, and we do recommend a competent, HIPAA-trained healthcare compliance counsel is on the phone that day. The next is you conduct a risk assessment. Once you've notified counsel and said that there's an issue, and they're in the process of getting retained and onboarded and getting going, you need to conduct a risk assessment. You have to determine, did they actually get in, or did they just try to? Was it 150 attempts at the firewall that never actually went through, or did someone actually get access to the server? You also need to figure out how many patients are affected and what data specifically was touched or otherwise exfiltrated. This can include, but is not limited to, dates of birth, addresses, names, any kind of facial pictures that might be in the patient's record, as well as really any pertinent medical diagnosis. If someone touches that is not supposed to have it, we go back to the previous slides. That's a suspected breach, and you need to take steps to cure it. Finally, start keeping a paper trail. Document details of the suspected breach, conduct a 4-factor analysis, Make sure you are keeping records. What did you notice? When did you notice it? What steps did you take as soon as you noticed it? Because the more of those types of papers you can provide to your counsel, if and when OCR comes knocking, the easier it's going to be for everybody involved. Here's when we noticed it. Here's what we did about it. Here's who we called. We are telling you because we have to, but we're trying to take steps to correct the issue. And there's been some cases that, in my personal experience, that has knocked us down tiers of that Heidi was referring to earlier, saying, okay, you could have done more in preparation for this, but once you noticed it, you took all reasonable actions, and some people that I'm aware of have gotten off a little bit lighter because of it. The next day, once we've established all of that, we go to our old friends, insurance. Next slide, please. Between contacting the insurance and the next 60 days, this is where it gets complicated. We strongly encourage you to review your professional liability coverage. I am personally aware of several coverage options with at least one carrier that has cyber coverage in the event of a third-party breach. If you have it, you need to look into it, see what qualifies as a breach, and see if your insurance carrier will front any or all of the costs associated with fixing the problem. If you don't have it, while we cannot make the decision to get any for you, we will say that these breaches can get very, very expensive for some reasons I'm about to get into, and it's a lot easier if you can have insurance foot the bill rather than the business eating those costs. Because in the next 60 days after the breach, we're going to conduct a forensic analysis if appropriate. That's usually a very complex and very technically savvy IT team. Once again, no disrespect to anybody's in-house IT folks, but on a breach, we're not dealing with a lost password or a reset credentials. You're dealing with IT passwords. Did anybody make a backdoor? Is there a virus in your system that is waiting for someone to click something to lock everybody out of their computers? Forensic analysis on the cyber sphere can address those quickly and efficiently. You need to apply new fixes, including new equipment and remote monitoring, as well as notifying the affected individuals by mail, notifying the media, and posting a notice on your website if the breach is large enough. And like I mentioned earlier, if the breach is over 500 individuals, you are required to report it to OCR. To my knowledge, and Heidi can feel free to correct me, this is regardless of whether the PHI was encrypted or not encrypted at the time of the breach. If over 500 individuals are affected, you are required by law to notify OCR that the breach has occurred and take all the necessary subsequent steps that come with telling the feds you are technically in violation of HIPAA. Have fun with that. And then once the fixes are in, you should conduct another SRA. Okay, a breach happened, we fixed it. Did the fix actually take? Is everything closed up? Is everything put where it's supposed to be? Following that, you're going to deal with a lot of alphabet soup. The OCR folks are going to come and go, depending on the threat actor involved. There may be corollaries with the FBI. I've personally seen it, and while I don't have any outwardly negative things to say, I do know that when the FBI showed up, everyone got real scared. You need to update your policies and procedures on your HIPAA breaches. You need to make sure that everyone is aware of the do's and don'ts of keeping a secure cyber environment. Conduct additional staff training on those policies if necessary, and institute a policy or procedure to conduct SRAs annually. The more prevention you can do ahead of time, the more you can stay out of the crosshairs when things go awry. Next slide, please. So there are some affirmative defenses under the privacy rule. Now, as a brief technical liaison into law school, an affirmative defense is essentially a legal excuse saying, I broke the law, but, and it then falls to you or whomever the party is that is asserting the defense to prove that you met all the requisite bullet points of whatever that defense requires to say, but it's okay because X, Y, Z, whatever the affirmative defense that you're using says. There are several defenses available designed to encourage an entity to mitigate these violations. These defenses provide flexibility in circumstances where compliance would be otherwise unreasonable. Therefore, the Secretary may not impose civil monetary penalties if the covered entity establishes, to the satisfaction of the Secretary, it did not have knowledge of the violation and, by exercising reasonable diligence, would not have otherwise found out that violation occurred, or the violation is due to reasonable cause and not willful neglect, and was corrected during either the 30-day period beginning on the date the liable entity knew or should have known the violation occurred, or a period otherwise determined by the Secretary as applicable by the facts. Translated from legalese, this means you either did your due diligence ahead of time and prevented it, and it was a genuine accident, or you could have done everything within your power and a breach still occurred, and the Secretary may waive CMPs if you otherwise satisfy this affirmative defense. They may also not impose the civil monetary penalties if the act is punishable as a criminal violation under Chapter 42 of the United States Code. This is not the get out of jail free card it sounds like, because no, you're not getting tagged with civil monetary penalties. Someone's getting charged with criminal activity. It establishes much higher penalties for the knowing wrongful disclosure of individually identifiable health information. So you get out of civil monetary penalties in exchange for jail time being on the table. You don't want to do this unless you absolutely have to, but it is there, and so we put it in these slides. Next slide, please. So the contents and requirements of the breach notice, you have to notify the affected individuals. They must notify the breach entity must notify impacted individuals as soon as possible, but no later than 60 days from the date of discovery of the breach. There are exceptions, because there always are, in the state of Louisiana for no specified time limit, whereas Texas has a very clear, hard 30-day time limit. You should familiarize yourself with your HIPAA notice requirements so that you, at the barest minimum, are armed with all the information of what to do if and when a breach occurs. You will be required to provide a brief description of what happened, the date of the breach, and the day you discovered it. Those are likely two separate days, but could be the same one. What type of unsecured PHI was involved, the steps the patients should take to protect themselves, what the covered entity is doing to investigate the breach, otherwise mitigate the loss, and to protect against future breaches like this going forward. And finally, contact procedures if there are any questions or follow-up for these protected individuals. Next slide, please. You should send notice to the patient via first-class mail to the last known address of the person, or if that person is known to be deceased, their next of kin or their closest representative. Any breach involving 10 or more individuals, the entity is allowed to post a notice on its website for, at a minimum, 90 days and include a toll-free number for individuals to call and check whether the notice applies to their individual PHI, or to provide notice via a major newspaper or broadcast media in the geographic areas where the impacted individuals are likely to reside. Tongue twister, that one. Any breach involving more than 500 individuals, once again, you have to notify the Secretary. This is not a do not pass go, do not collect $200. If more than 500 people are breached, you have to tell the Secretary. And at the same time, you must notify the impacted individuals and the prominent local media. This is not a may. This is a you must at 500 plus. And the notification to the Secretary for breaches of unsecured protected PHI involving less than 500 individuals, a covered entity shall maintain, which is a must under law, a log or other documentation of such breaches, and no later than 60 days after the end of every calendar year, notify the OCR as appropriate of any subsequent breaches. Next slide, please. So there may be individual recoveries coming down the pipe for HIPAA. Generally speaking, HIPAA did not, up until recently, have an individual right of recovery, with some noted exceptions that I won't get into for purposes of time. Patients harmed due to a breach may receive part of these penalties. The Health Information and Technology for Economic and Clinical Health Act, shortened to HITECH for the purposes of everyone's tongues, amended HIPAA's enforcement structure. A patient is harmed as clear as the law ever makes anything. Section 13410C2 of HITECH requires a recommendation for a methodology distributing a percentage of civil monetary penalties rendered to an, quote, individual who is harmed by a HIPAA violation. Section 13410C3 goes on to require that the Secretary of Health and Human Services establishes regulations based on the recommendations for distributing these monies no later than 3 years after the HITECH was passed. Conversations with the Office for Civil Rights reveal that the implementing regulations are currently being drafted. As of the time of this writing, once again, they're not law, so we can't tell you what they are exactly, but we do know that they are currently on someone's desk, and they are likely coming down the pipe in the near future, but we don't know when, and we don't know what they're going to look like. Next slide, please. So, as I mentioned earlier, there is an affirmative defense that gets you into the criminal world. There are criminal sanctions available under HIPAA. The DOJ is responsible for investigating potential criminal violations of HIPAA. Generally, they use Chapter 42 of the United States Code, Section 1320D6. That is the criminal enforcement provision of HIPAA, and it's used to prosecute criminal violations. There are 3 levels. The first is a punishable misdemeanor by a fine of up to $50,000 and/or imprisonment of up to 1 year. That's a level 1 criminal violation. Level 2 is there are certain aggravating factors that may make an offense into a felony conviction. Subsection B2 provides for fines of up to $100,000 and/or imprisonment of up to 5 years for failure to appropriately maintain HIPAA standards. And the third level, this is where you start getting into the really bad actors. Subsection B3, if the crime is with intent to sell, transfer, or use individually identifiable health information for commercial advantage, personal gain, or malicious harm, the fine may be up to $250,000 and a 10-year prison sentence. Next slide, please.
And let me just add, in case people think that this is all theoretical, there are, in fact, people who have been criminally charged under HIPAA and are serving time.
So here's the practical considerations. We're going to touch again once more on my good friends in the cybersecurity industry, and specifically their insurance. As healthcare providers, obviously everyone wants to make sure that they keep the lights on, the staff paid, and the patients cared for. We can't tell you what exactly is the best product for HIPAA security. There's a number out there for cybersecurity insurance provisions. Your business is charged with measuring the access, the cost, and the affordability of that insurance provision. Some professional liability products will carry it as a sub-rider in terms of it's not the primary thing this policy is supposed to do, but we'll chuck a couple of bucks your way just in case. Or I am aware of several other products where that is the entire point of the policy, is to stand in readiness of a cyber breach. Obviously, one is more expensive than the other, and it falls to you, the business, to determine how much cyber coverage you need and when and how you're going to obtain it. Coverage elements are key here. You need to read, reread, and ask questions if you don't understand what you are being covered for and what you're not being covered for. There are various different types of cyber breaches that can happen. There can be third-party access. There can be worms. There can be firewall breaches. There can be router viruses. There can be duped credentials. There can be a whole host of things. You need to make sure that the cyber coverage you buy actually covers what you think it covers. There are always exclusions and coverage limitations written into every policy, including the most common are for nation-state actors or other similar limitations. You need to be aware of what those are and when they kick in so that you're not blindsided when insurance says your matter is not covered. Finally, you're weighing the value of the policy and what protection it can give you versus the gaps in coverage that are inherently there, either in the policy outright doesn't cover it or it's been written in such a way that it would, except they said no. And you need to be aware of the contract, because that is what an insurance policy is, the contract that you are signing when you take on cybersecurity insurance. Next slide, please. Some more practical considerations are how to access your coverage at the time of a breach or a potential breach. First things first, you need to know who you're calling and what you're doing first. As we outlined previously, we strongly recommend getting the lawyers on the phone before you get the insurance carrier. You want to protect yourself legally before you really fight over who's paying the bill. That argument, if there is one, can come later. First things first, you need shields up on legal liability. From there should probably be a appointed person, your HIPAA security expert or their equivalent in your facility, who, okay, there's a breach happened, initiate protocol, whatever. Who's calling the insurance carrier? Whose job is it? How are they going to do it? Are they going to have non-implicated devices, i.e. a personal computer or cell phone that they use as a point of contact outside of what could be a afflicted cyber sphere? What does that look like? That needs to be done ahead of time. We are well past the point in today's digital age of we'll fix it when it breaks and not before. You need to get ahead of this curve. I cannot stress it enough. You should also understand the role of carrier-appointed cyber experts and attorneys. Several carriers have personal lists that they've signed and said, we may cover your cyber breach, but you're working with these experts and these attorneys. If that is the case, you should know who those people are, and they should be the ones you speed dial if and when everything goes upwards. And finally, the role of the covered entity. As the healthcare facility, your job is to protect the HIPAA records and keep the PHI protected. What is your facility's job and the role of your staff in the event of a breach? Everyone needs to be on the same page so that no one either willingly or unwillingly makes the problem worse as it's going on. It gets complicated quickly, and the more cohesion you can have as a unit within your facility, the more headaches you can save yourself. Next slide, please. Lastly, we strongly recommend conducting a cyber fire drill now. Pretend, for want of a better term, that a cyber breach has occurred. Is your facility capable of responding in a timely and appropriate fashion? Do you have identified staff members who are supposed to respond, know who they're calling, and know who they're getting on the phone? After the drill is concluded, you should mitigate weaknesses and strengthen your cyber readiness. The drill should expose the root causes of what could be a potential breach and the lessons learned during that breach. You need to make sure you are consistently doing your risk analyses and develop your mitigation plan after, as well as stepping up security training in HIPAA and embedding cyber awareness into your culture, as well as developing and drawing on your experts. In closing, before we turn to questions, I do want to give a disclaimer. We know that most of the people attending this seminar are medical experts. You went to med school or nursing school, or you got some field in medicine to help patients. Cyber is not what you went to school for. And we understand the frustration that comes with there's more and more rules every day coming down the pipe. Our job is to tell you, you don't have to like it, but it is the law. And it is your responsibility to uphold and protect that law as it stands. We don't get to change it just because we don't like it, and OCR will level penalties whether you agree to cybersecurity or not. This is the current statement of the field. And I think that takes us to questions right on the money of time. Liz, did we get any questions in the panel while we were presenting?
I don't see any questions posted, so I think you covered everything.
Okay, so I think the next slide is our closing. Once again, just as a brief disclaimer, this is general information only. It is not legal advice and should not be substituted for legal counsel. Heidi and I are happy to help you once you do fully retain the firm and we have an opportunity to look at your case. Heidi, did I miss anything?
Nope, that's it. And just, if I can summarize in 3 words what today's webinar is all about: SRA, SRA, SRA. Do your SRA. So many circumstances where we see people don't have an SRA. And there are ways to get it done. Don't delay on doing this. This is something you should easily be able to put your hands on, because, in my opinion, there are two kinds of healthcare providers. Those that have had a breach and that know about it, and those that have had a breach and that don't know about it. The odds are you've already had some kind of breach and you simply don't know about it. So do what you need to do ASAP.
All right, and I think that takes us home. Thank you for joining us. Thank you for sitting in on our webinar. It's been a pleasure to present for you, and everyone have a good day.
Thank you all. Bye-bye.
Bye-bye.